The Netherlands is a civil law country. Its laws are written and the application of customary law is exceptional. The role of case law is small in theory, although in practice it is impossible to understand the law in many fields without also taking into account the relevant case law. The Dutch system of law is based on the French civil code with influences from Roman law and traditional Dutch customary law. The new civil law books were heavily influenced by the German Burgerliches Gesetzbuch. The primary law-making body is formed by the Dutch Parliament in cooperation with the government. When operating jointly to create laws, they are commonly referred to as the legislature. The power to make new laws can be delegated to lower governments or specific organs of the state, but only for a prescribed purpose. A trend in recent years has been for Parliament and the government to create framework laws, and delegate the creation of detailed rules to ministers or lower governments. The Ministry of Security and Justice is the main institution when it comes to Dutch law. Areas of law. The domain of Dutch law is commonly divided in the following areas: administrative law, civil law, criminal law, constitutional law, European law, international law. Civil law. Civil law is the domain of law that regulates the everyday life of persons and other legal entities. The main code of Dutch civil law is the Burgerlijk Wetboek. Copyright law, nationality law, criminal law. Criminal law deals with the prosecution and punishment of criminal offences. The main code is the Wetboek van Strafrecht. Constitutional law. Constitutional law involves itself with the constitution and the structure of the Netherlands. It involves the powers of democratic institutions, the organization of elections and the divisions of powers between central and local governments. See also the article on the Constitution of the Netherlands. Following the practice of many civil law jurisdictions and in contrast to practice in nations such as the United States, the practice of Dutch constitutional law is that judges are not allowed to determine the constitutionality of laws created by the legislature. Administrative law. Administrative law is the area of law that regulates the operation of the various levels of government and the way persons and legal entities can appeal decisions of the government. The basics of Dutch administrative law were overhauled completely in 1994 with the advent of the new basic administrative law. European law. European law deals with the influence of laws and regulations of the European Union in the laws of the Netherlands. International law. International law involves the application of international laws in the Netherlands. The Dutch constitution contains a clause that allows the direct application of most international laws in Dutch courts. The laws that regulate jurisdiction and applicable law in cases with an international aspect are not part of international law but form a specific branch of civil law. History. From ancient times, the lowlands that became the Republic of the Seven United Netherlands were ruled by a patchwork of customary law with a more or less prevalent role for Roman law as a secondary source of law. This period of customary law ended in 1806 when the Dutch Republic ceased to exist and the Kingdom of Holland was created under French rule. With French rule came a French way of running the state, a centrally led and efficiently operating civil service and a new system of positive law, the Code Civil. After the defeat of Napoleon, a new Dutch state was created, comprising the Netherlands and Belgium. The Dutch did not want to go back to the days of legal diversity, and a project was started to create a Dutch civil law book. After the breakaway of Belgium in 1830, the new law book had to be overhauled again to be cleansed of Belgian influences. The new law book gained force of law in 1838. After the Second World War, Professor E.M. Majors was commissioned to create a new civil law book. After his death in 1954, work on the new law book continued, but the process was slowed down considerably. Nevertheless, his new civil law book entered force in various parts over a period spanning from 1970 to 1992. Book 4 was overhauled in 2003.